You are listening to a series of 10 podcasts on the foundations of American government and politics, presented by Citizen U. Episode 3. Explain how the U.S. Constitution, when ratified, impacted the role of the central government. The original U.S. Constitution was organized in 7 articles or sections. Article 1 describes and enumerates the powers given to our legislative branch. The legislative branch is often called our first branch. Our bicameral Congress has 3 primary responsibilities. 1. Make laws. 2. Provide oversight to the rest of the government. 3. Represent their constituents through casework. Originally, only the House of Representatives was directly elected. At our founding, senators were appointed by the respective state legislatures. The times, places, and manner of all elections would be determined by each individual state. Article 1, Section 8, enumerated the basic express powers given to our Congress. The most notable powers given to the legislative branch were the right to raise taxes, declare war, and to regulate interstate commerce. The Interstate Commerce Clause would prove to be the most frequently used provision to expand the power of our central government. The most controversial power, however, is found in Article 1, Section 8 and Clause 18. Called the Elastic Clause, the Necessary and Proper Clause empowers our legislative branch to pass any law that is related to one of its expressed powers. Needless to say, this provision has been used to extend the reach of government whenever the vague language of the Constitution proved inadequate. In the end, our legislative branch has been given the power of the purse. The United States Congress is responsible for collecting all revenues necessary to cover the appropriations of our government according to the prepared budget. Article 2 describes and enumerates the powers given to our executive branch. Though given the power of the sword, our early presidents were considered relatively weak. Presidential authority was based more on personality than the express powers found in the Constitution. That is why the legislative branch overshadowed many of our earliest presidents. Nevertheless, the Constitution empowers the president to be commander-in-chief, to appoint with the advice and consent of the Senate ambassadors, judges, and other officials of the executive branch. Ultimately, the president was empowered to faithfully execute the laws passed by the legislative branch. As is still true, the original Constitution created an indirect means to elect our president. Our framers feared democracy as much as they feared monarchy. An electoral college was created to provide a filter between the direct votes of citizens and the selection of our chief executive. Presidents can be removed through impeachment. The House of Representatives can accuse the president of high crimes and misdemeanors, but only the Senate can hold the trial to remove him from office. Article 3 describes the powers of the judicial branch. Alexander Hamilton called the judiciary the least dangerous branch. The authority of the Supreme Court would grow as subsequent Congresses gave it more and more power. The Supreme Court was empowered to interpret what our laws mean. Article 4 describes the relationship between the central government and the states. The Constitution guarantees a republican form of government. The full faith and credit clause assures that all states will respect the laws of the land. This also includes the laws of other states. The Privileges and Immunities Clause has also been used to legally bind the state governments into one cohesive unit. Article 5 describes the means by which the original Constitution could be amended. The process may appear straightforward and simple. As of today, however, our Constitution has only been amended 27 times. The most common way to amend the Constitution is for a proposal to be made by 2/3 of Congress, and then a ratification vote by 3/4 of the state legislatures. Though never used as such, proposals can be made by national conventions with ratification by state conventions. Article 6 assured that the debts of the United States carried over from the Revolution would be honored and paid. Article 7 prescribed that 9 of the original 13 states would be required to ratify the new Constitution. Though the U.S. Constitution does not mention political parties, 2 primary factions debated its merits. The Federalists advocated for a stronger central government and pushed hardest for ratification. Anti-Federalists were suspicious of granting too much power to the new national government. The most significant reservation was over a Bill of Rights. The Federalists claimed that the essential civil liberties were already contained within the original Constitution. The writ of habeas corpus, show me the body, protects all citizens from unlawful detention. Bills of attainder were prohibited. All citizens would be guaranteed a trial by a judiciary. Nor could citizens be convicted through ex post facto laws. One cannot apply law after the fact or retroactively. Federalists argued that the central government with its limited powers would be unable to infringe upon personal liberty. Anti-Federalists held out for the assurance that a Bill of Rights would be added. You have been listening to a series of 10 podcasts on the foundations of American government and politics, presented by Citizen U.